Welcome to this lecture on personal laws and religious autonomy. Personal laws in India are a unique feature of its plural legal system. They govern matters such as marriage, divorce, inheritance, and succession within religious communities. Rooted in scripture, custom, and colonial codification, these laws reflect India's respect for religious diversity. The Constitution safeguards religious freedom under Articles 25 and 26, but also subjects it to public order, morality, and health. And at the same time, the state has been given power to restrict freedom of religion in the interest of any secular activity or welfare activity or social reform. Thus, while individuals are free to practice their faith, personal laws must conform to constitutional principles. The framers recognized that religion deeply influences family and social life, making personal law autonomy necessary for cultural preservation. However, the coexistence of multiple systems raises questions of equality and gender justice. The judiciary has repeatedly interpreted how far religion can dictate personal laws. Cases like Shah Bano in 1985 and Shaira Bano in 2017 demonstrate the tension between reform and tradition. India's challenge remains balancing religious freedom with universal right to equality. Personal laws, therefore, serve as a testing ground for the Constitution's promise of secularism, respecting faith while ensuring justice for all citizens in a diverse democratic society. Historical evolution of personal laws in India. The concept of personal laws predates colonial rule. In ancient India, Dharmashastra texts governed family and property relations amongst Hindus, while Islamic law based on the Sharia guided Muslims. During British rule, the colonial state formalized these systems by codifying Hindu and Muslim personal laws while introducing secular criminal and commercial codes. The British policy of non interference in religion institutionalized legal pluralism. This division created separate identities with a unified political framework. Post independence, the Constituent Assembly debates whether to retain or reform personal laws. Leaders like Ambedkar supported uniformity through gradual reform, while others insisted on preserving religious autonomy. As a result, personal laws remained but were reformed within communities over time, or there was a clear mandate from the Constitution to gradually reform the personal laws in a way that it finally leads to gender equality and gender justice. The Hindu Code Bill 1955 to 56 marked major change, while Muslim, Christians, and Parsi laws evolved separately. This layered history shows that India's legal pluralism is not accidental, but a product of balancing faith and reform. Personal laws thus represent both tradition and transition, reflecting India's journey towards equality without erasing diversity. Constitutional position of personal laws. The Constitution of India neither abolishes nor explicitly protects personal laws, but they function within its broad framework of secularism, equality, and gender justice. Articles 25 and 26 guarantee freedom of religion, while Article 44 directs the state to work towards uniform civil code. Personal laws are recognized as part of cultural autonomy but must respect constitutional morality. Courts have debated whether personal laws fall within law under Article 13, which invalidates any law inconsistent with fundamental rights. The Bombay High Court in the State of Bombay versus Narasu Appa Mali 1952 held that personal laws are not laws in force under Article 13 and therefore cannot be struck down as unconstitutional. This judgment still influences legal interpretations. However, subsequent judicial reasoning and public debate continue to question this distinction. The Constitution thus creates a delicate balance, protecting religious freedom under Article 25 to 26, yet allowing reforms in the interest of equality and social justice to ultimately achieve gender justice. Personal laws, therefore, exist not outside but within the moral and legal boundaries of constitutional democracy. Scope under Article 25. Article 25 guarantees every individual the freedom of conscience and the right to profess, practice, and propagate religion. This right applies equally to all citizens, subject to public order, morality, and health, and other fundamental rights, as mentioned in this chapter. The four personal laws, Article 25 ensures that religious customs governing family and inheritance are protected so long as they do not violate constitutional principles. The Supreme Court has clarified that religion includes essential practices integral to faith, but not social customs that may discriminate. In Shirur Mutt, the court held that what constitutes an essential religious practice is to be determined by the courts, not the clergy. This interpretation allows the state to reform non essential or discriminatory practices. Thus, Article 25 serves both as a shield and as a filter, preserving genuine religious freedom while enabling reform of unjust customs. Personal laws therefore operate under Article 25's protective but conditional framework, where faith is respected yet aligned with the evolving idea of constitutional morality and equality in India's secular democracy. Article 26 complements Article 25 by granting every religious denomination the right to manage its own affairs in matters of religion, establish institutions, and own property. It protects collective autonomy and organizational freedom. However, this autonomy is not absolute. It is subject to public order, morality, and health. For personal laws, Article 26 becomes relevant when religious bodies claim control over family, marriage, or succession practices. The Supreme Court has repeatedly clarified that while religious institutions enjoy independence in spiritual matters, laws regulating secular aspects of religion can be reformed by the state. For instance, in Shirur Mutt, the court distinguished between matters essentially religious and those secular in nature. This principle allows us, the state to introduce social reforms without infringing genuine faith. Article 26 thus preserves the spiritual core of religion while empowering democratic institutions to modernize its social expressions. It ensures that personal law autonomy functions within the ethical boundaries of equality, justice, and national unity. Distinction between law and religion. One of the key constitutional challenges in India lies in distinguishing between religion as faith and law as a social instrument. Religion governs belief and spiritual conduct, while law regulates social responsibility or social relationships. Personal laws sit at the intersection of both. The judiciary has played a major role in defining this boundary. In Narasu Appamali case, the court held that personal laws, though religious in origin, are legal norms once enforced by the state. Subsequent cases refined this view, emphasizing that religious freedom cannot justify practices contrary to fundamental rights. For example, untouchability, child marriage, and polygamy have been restricted through secular legislation. The courts interpret essential practices narrowly, ensuring that only spiritually indispensable customs remain protected. This separation allows India to maintain secular governance without erasing religious identity. Thus, personal laws are respected as cultural heritage but must evolve within the larger framework of social reform and constitutional morality, where justice prevails over unchangeable orthodoxy. Overview of Hindu personal law. Hindu personal law underwent extensive reform soon after independence. Based on Dharmashastra principles, it traditionally governed marriage, inheritance, and succession. The Hindu Code Bills 1955 to 56 or passed in these years, including the Hindu Marriage Act, Succession Act, Adoption and Maintenance Act, and Minority and Guardianship Act, modernized these laws as per the need of the hour. The reforms introduced monogamy, divorce rights, and equal inheritance for women. As we know that divorce is not acceptable as per the Dharma Shastras, but has been created artificially through this reformation in personal laws. These laws apply not only to Hindus but also to Sikhs, Jains, and Buddhists, reflecting the inclusive definition in Article 25, Clause 2, Subclause B. The reforms balanced faith and equality, demonstrating the state's role in harmonizing tradition with justice. While largely secularized, Hindu law retains cultural rituals in marriage and inheritance. Judicial interpretation continues to ensure gender equality, as seen in Vinita Sharma versus Rakesh Sharma in 2020, granting daughters equal co partnership rights. Hindu personal law thus illustrates India's model of gradual legal reforms, preserving cultural identity while aligning personal rights with constitutional principles of equality and dignity. It is because of this codification of Hindu personal law that Hindu women are at par with Hindu men as far as the inheritance and property rights are concerned, which is the main issue of or the bone of contention or main issue challenging gender equality and gender justice. The one who controls property controls the power. And therefore, over the years, Hindu women has got equal rights in ancestral property, parental property, agricultural land, and also the equal co-partnership rights, which is a big leap in gender justice as far as Hindu personal laws are concerned. Overview of Muslim personal law. Muslim personal law in India is primarily governed by the Muslim Personal Law Sharia Application Act of 1937, which codified religious law on marriage, inheritance, and divorce. Unlike Hindu law, it remains largely uncodified and based on interpretations of the Quran, Hadith, and juristic schools such as Hanafi and Shafi. It upholds the validity of nikah, meher, and iddat while emphasizing consent and contractual equality. However, certain practices like triple talaq at one instance and polygamy or halala have been challenged for violating gender justice. In Shah Banu case, the Supreme Court held that divorced Muslim women or destitute divorced Muslim women were entitled to maintenance under Section 125 CRPC, which gives lifelong maintenance to destitute men, women, and children, prompting national debate. Later, Shaira Banu versus Union of India declared triple talaq at one instance as unconstitutional, affirming equality under Article 14. These judgments show that while religious autonomy is respected, personal laws must conform to constitutional morality and the constitutional ideal of gender justice. The evolution of Muslim law thus reflects the balance between religious faith, social reform, and the pursuit of gender justice in our secular state. Overview of Christian and Parsi personal laws. Christian and Parsi communities follow distinct personal laws rooted in colonial codification. The Indian Christian Marriage Act of 1872 and the Indian Divorce Act of 1869 govern marriage and divorce amongst Christians. The Parsi Marriage and Divorce Act of 1936 applies to Parsi community. These laws, though religiously framed, have undergone tremendous amendments to align with constitutional equality and the ideal of gender justice. The Indian Divorce Amendment Act of 2001 made grounds for divorce gender neutral for Christians. Parsis enjoy equality in succession under the Indian Succession Act of 1925, reflecting early reform. Courts have ensured that religious rights coexist with the legal protections. In John Valamattam versus Union of India in 2003, the Supreme Court struck down discriminatory sections denying Christians equal testamentary rights, reaffirming Article 14. Both laws now balance faith with gender and legal parity. Christian and Parsi personal laws illustrate that religious autonomy can coexist with modern legal reform, embodying India's plural yet constitutionally unified vision of justice and equality. Article 13 and Judicial Review of Personal Laws. Article 13 declares that any law inconsistent with fundamental rights is void. However, whether personal laws fall under laws in force remains debated. The Narasu Appamali decision held that personal laws are not subject to Article 13, distinguishing them statutory enactments. Critics argue that these interpretation isolates personal laws from constitutional scrutiny, allowing discrimination to persist. Later judgments, while not overturning Narasu, have indirectly reviewed personal laws through broader equality principles. For example, Shaira Bano struck down triple talaq at one instance as arbitrary under Article 14, indirectly subjecting personal laws to constitutional review. The courts increasingly interpret fundamental rights expensively, applying constitutional morality over rigid traditionalism. Though Article 13's direct application remains contested, judicial trends affirm that no law or custom can override equality and dignity. The evolution of judicial review signals India's gradual shift towards harmonizing personal law autonomy with constitutional supremacy, a balance essential for sustaining both secularism and pluralism. The debate on Uniform Civil Code UCC debate reflects India's struggle to reconcile unity with diversity. Enshrined in Article 44 of the Directive Principles, the UCC urges the state to secure a common civil code for all citizens. Proponents argue it promotes gender equality and national integration by replacing religion based personal laws with uniform standards. Opponents fear it may erode cultural and religious identity, violating Articles 25 and 26. The Constituent Assembly deferred its implementation, preferring gradual consensus. Judicial observations in Salamudkul and John Velamatham urged the state to move towards uniformity while recognizing India's plural reality. The Law Commission's 2018 report advised reform within communities rather than one uniform law. The debate, therefore, is not about uniformity versus faith or imposition or the fear that there will be an imposition of the majority culture and faith. It is about balancing equality with autonomy with the purpose, long term purpose of achieving gender justice. The UCC remains a constitutional aspiration, symbolizing India's ongoing quest to harmonize diversity with justice through progressive, inclusive, a reform rooted in dialogue, not imposition. Gender justice and personal laws. Gender equality remains a critical test for personal law reforms in India. Many religious laws historically privileged men in matters of marriage, divorce, and inheritance. Constitutional principles, however, mandate equality under Articles 14, 15, and 21. Courts have played a transformative role in by expanding women's rights within personal law systems. In Shah Banu, the Supreme Court upheld a destitute Muslim women's lifelong right to maintenance. In Vinita Sharma, it granted Hindu daughters equal co-parental rights. The Shaira Banu verdict against instant divorce reaffirmed that religious freedom cannot justify gender discrimination. These judgments mark a shift from tolerance of inequality to enforcement of justice within faith systems. Reforming personal laws for gender justice does not negate religion. It fulfills the Constitution's moral promise of equality in diversity. True autonomy lies not in preserving inequality, but in enabling every individual, regardless of gender or faith, to enjoy freedom with dignity and fairness. The judicial interpretations and the essential practices doctrine. The essential practices doctrine developed in Shirur Mutt determines which religious practice merit constitutional protection. Courts distinguish between essential religious rituals and non essential social customs. This doctrine shapes judicial review of personal laws by allowing reform in areas not central or essential to faith. For instance, the abolition of triple talaq at one instance and reform of Hindu succession laws were upheld as they concerned social, not religious practices. The doctrine enables a dynamic interpretation of Articles 25 to 26, ensuring religion is not misused to justify discrimination. However, critics argue that judicial determination of essentiality risks excessive state intervention in faith matters. Despite this, the doctrine remains vital for balancing autonomy with equality. It preserves freedom of belief while allowing progressive adaptation of personal laws. The essential practices test thus argues that India's secularism is neither anti religious nor passive, but actively committed to justice within faith traditions. Personal law reforms and constitutional morality. The concept of constitutional morality, emphasized in recent Supreme Court rulings, requires all laws, including personal laws, to conform to the values of liberty, equality, and dignity. It ensures that faith based norms evolve alongside democratic ethics. In Navtej Johar versus Union of India in 2018, the court reaffirmed that personal morality cannot override constitutional morality. This idea directly influences personal law reforms, especially regarding gender inequality. The Shaira Banu case exemplifies this principle, declaring triple talaq unconstitutional because it violated women's dignity. Constitutional morality guides reform without denying faith, ensuring that religion thrives within the framework of justice. It transforms secularism from mere tolerance to active respect rooted in equality. Through this lens, personal laws are not static religious codes but evolving instruments of social harmony. Upholding constitutional morality ensures that personal law autonomy strengthens rather than undermines the inclusive and ethical vision of India's democracy. Comparative perspective, religion and law in other countries. Many multicultural societies grapple with the tension between faith and law. In countries like United Kingdom, personal law is not recognized. Civil law governs all citizens, though faith-based arbitration is permitted. Israel maintains separate religious courts for Jews, Muslims, and Christians, similar to India's plural system. In Indonesia, Islamic law applies to Muslims in personal matters within a secular state framework. India's model stands out for constitutionality or constitutionally protecting both diversity and equality. Unlike strict secular systems, it accommodates religion within democratic limits. Comparative study shows that absolute uniformity often breeds resistance, while gradual reform fosters inclusivity. The Indian approach thus reflects pragmatic secularism, acknowledging pluralism while striving for equality through law. Understanding global parallels clarifies that personal law reform is not about eliminating religion, but aligning it with the modern principles of justice, reflecting India's constitutional vision of unity through respectful diversity. Well, challenges in balancing faith and reform. Balancing religious autonomy with the constitutional reform poses ongoing challenges. Deep rooted beliefs, political polarization, and fear of cultural erosion often hinders dialogue. The plural nature of India's society makes uniform solutions complex. Resistance to reform is stronger when it appears externally imposed rather than community led. Courts and policymakers must therefore approach personal law reform with empathy and consultation. Another challenge lies in consistent judicial interpretations, which sometimes create uncertainty. Legislative inertia also delays uniform progress. Yet, without reform, inequality persists, especially against women. The solution lies in gradual, inclusive reform, respecting belief while upholding justice. Civil society, religious scholars, and women's organizations play a vital role in bridging this gap. True secularism demands that religion and reform coexist harmoniously, guided by constitutional morality. Balancing these values remains one of India's most profound democratic responsibilities, shaping the nation's identity as both deeply spiritual and firmly constitutional. To conclude, personal laws in India embody both the richness and complexity of its pluralism. They affirm religious freedom under Articles 25 and 26 while challenging the nation to uphold equality under Articles 14 and 15. Judicial interpretation has gradually transformed these laws from a rigid tradition into evolving expressions of justice. Through decisions like Shabano, Salamudgal, and Sharabano or Vinita, the courts have reaffirmed that faith cannot override fundamental rights. India's model of reform within religion reflects constitutional wisdom, preserving diversity while pursuing gender and social justice. The future of personal laws lies not in abolishing differences but ensuring fairness within it. By aligning religion with constitutional morality, India strengthens both faith and freedom. Personal laws thus remain not relics of the past, but living frameworks continuously tested and refined by democracy. Their evolution marks the journey of a nation striving to harmonize belief, equality, and justice in one enduring constitutional vision.